Hello, and welcome to part 3 of our trial preparation workshop regarding your trial date. In this series, we will cover what your case is about, using your answer or court documents to get ready and prepare for your court date, what to do in court, and actually presenting your case to the judge. The first thing that'll help you prepare for your case is to understanding what your eviction case is about. If you look to your complaint, the notice attached will tell you exactly what the focus of the case is. Some common examples of case types are for non-payment of rent, nuisance, breaking the rules of the lease regarding pets or visitors, or no-fault reasons, where you did nothing wrong, but the owner decides they want a family member to move in, they want to renovate, make major repairs, it's the end of the lease term, or you were staying there without paying rent. You will want to use your answer as kind of your guide for your trial date. Your answer should have identified defenses. For example, if you had not been able to pay your rent or weren't paying your rent, it may have been because of bad conditions at the premises that the landlord would not repair. You'll want to create a list of every defense listed on your answer. And for every defense that you have, write a list of items, people with information, or documents you have that proves your defenses. For example, if you have any papers, other notices, emails, text exchanges, you want to bring 4 copies to the court on your trial date. If you've received any official reports from government agencies, you will need to bring certified copies. So this may include an inspection report or a contract with the housing authority. In your list, you may want to include any people who may need to speak on your behalf at trial. Those are witnesses or people that may have seen or observed any of the things that you're describing in your defenses. Please know that you should never attempt to use secretly recorded video or audio of anyone as evidence. It likely will not be allowed in court and may put you at risk of worse problems, as it's technically a crime to record someone without their permission or knowledge. Some examples of evidence that you may want to bring to support your defense or your case are listed here. So if your landlord refused your rent, you want to bring in the money orders that have the dates on them. You may also have witnesses who saw the manager or the landlord reject your rent when you tried to pay it on time or within a 3-day notice period. If you have habitability issues or bad conditions, you want to bring photos of your bad conditions. You may have a report or a bill from a plumber or someone else who tried to make repairs on their own. You may have an inspection report from a governmental agency. Any of those types of evidence would support a defense of habitability. If you are arguing that the landlord waived or changed the terms of when the rent was due, you may want to show emails from the landlord or receipts showing rent was regularly accepted on dates later than was listed on the lease. So if you have a lease that says the rent is due on the 5th of the month, but you regularly paid on the 10th of the month or later, you want to have either your rent receipts, your money order receipts, or other documentation, or an email or a text from your landlord saying, as long as you get it to us by the 10th, it's fine. Those are all good examples of evidence that may support these types of defenses. Another thing that you really want to do is practice. 70% of the population is scared of public speaking, but you will have to speak loudly and clearly to the judge so that they understand what your case is about and they can hear you out. Practice talking out loud, not just in your head, before your trial date, and don't wait till the night before. You should be able to summarize your case or your side of the case in about 3 minutes or less. The shorter and more direct your summary is, the better it'll be for the judge to understand and to hear you out. So let's see some video about what may happen on the day of trial.
The judge will call your case and ask if you've been able to reach a settlement. If not, they will likely send you and your landlord into the hall to negotiate.
As I mentioned in my email, I'm willing to pay $500 additionally every month until I'm caught up on my rent. It's not good enough. I need all the money now, or it's not going to work out. Maybe if you give me a date that you can move out later this month, we can settle it that way.
If set for a non-jury trial or bench trial, the trial will likely take place right after negotiations. If set for a jury trial, the case will likely be continued to a different date.
Please state your appearances.
I'm Tanya Tennant, I'm the defendant.
And Jeremy Bendler on behalf of plaintiff Linda Landlord.
Your landlord or their attorney will go first, calling witnesses and questioning them. They may attempt to call you as the first witness, so be prepared for this. Keep your answers factual and to the point. Don't get caught up in trying to explain everything. You will have an opportunity to explain your side of the story when it's your turn to present evidence.
Counsel, you can proceed.
Thank you, Your Honor. What is your name for the record?
Tanya Tennant.
And do you know my client, Linda Landlord?
Yes, I do.
And did you receive a 3-day notice to pay rent on your door?
Yes, I did.
And did you pay that rent within the 3 days?
No,
And why didn't you do that?
I didn't have the money to pay for it.
Don't give your landlord any more ammunition to use against you. You will have the opportunity to question any of the witnesses that they call. Make sure your questions cast doubt on the story the landlord is trying to tell.
Presenting your case to the judge. As shown, you will go second, or a tenant goes after the landlord or their attorney. All witnesses must be present in court so they can be sworn in front of the judge. Make sure you have your 4 copies of any papers ready and take notes. So have a paper and pen handy when the landlord presents their case so that you can know what you need to address to counter the story that they're telling or to show that parts of the story that they're telling is not true. So if you have a non-payment case, what are important issues to raise? As mentioned before, ongoing problems with the conditions of your apartment. You'd want to include any contacts, including emails or text messages about the rent, the due date, with your landlord. If you have official inspections or reports about the problems in your apartment, make sure to bring those and make sure to have a certified copy. If you've received rental assistance, which shows that you don't owe all of the rent that they're demanding, bring those approved rental assistance applications. Otherwise, have proof of payment, money order receipts, bank deposit slips, or video evidence of you handing the landlord if you're paying in cash, which we do not recommend. You'd also want to have proof of mailing. Oftentimes, tenants mail a check or money order via certified mail or with return receipt requested. If you have witnesses, neighbors, friends who don't live there, or anyone else who was present when you tried to give the money to the landlord and they rejected it, bring that person in. If you have proof of retaliation to show other reasons why the landlord is trying to evict you, for example, if you've issued a complaint just before the notice was issued to a city agency, you may want to provide documentation of that. If you have any documentation or witnesses who can testify that the landlord maybe didn't like you because you had children there, or had mentioned anything that shows that there are other reasons why the management or the attorney may be targeting you. Again, it has to be documented by other witnesses or other paperwork or communications. Those are always helpful. In other types of UD cases, what may help? Again, witnesses, if they're saying you're a nuisance or you were involved in an altercation, witnesses may be very helpful. If the other side may have video evidence, you're allowed to look at it before they present it to the judge. Any contacts with your landlord, including emails, text messages, videos and photographs that were taken with their knowledge or in common spaces. Requests for reasonable accommodations if you have a disability or a member of your household has a disability. Medical documentation, such as a letter from your doctor. Police reports, restraining orders are other examples of documents that may be helpful. And any documented instances of retaliation would be very helpful to you. And it's hard to say without getting into more specifics. So perhaps you can join one of our live sessions for a question and answer period. If you have a COVID-related hardship, you want to have any records of your COVID-19 declarations, proof of job applications, medical records or bills, letters showing a loss of job or reduced hours, and increased childcare expenses. Please note that this doesn't apply to residents of LA County who did not live in the city of Los Angeles and could not pay rent from April to June of 2022, last year. So how do you present evidence to the court and question any witnesses? Here's some examples of what that may look like.
Defendant, are you ready to proceed?
Yes, Your Honor. So I realize that I'm here because I didn't pay rent for the past few months, but the reason I haven't been paying rent is because the entire apartment has been infested with roaches and my water has broken down for the past 3 months. I've called and texted and emailed the manager and the landlord and whoever else I could, and nobody's gotten back to me. I've been living without water, and a lot of other things in my apartment have been breaking down. Nobody's fixing anything for me. What am I supposed to do?
For physical evidence, make sure you bring 4 copies of each item. 1 for your reference, 1 for your landlord or their attorney, 1 for any witness you may call, and 1 for the court. Make sure to remain on your side of the courtroom and don't ever cross into the area between counsel table and the bench. This is called the well, and the judge won't like it. Before you begin talking about your evidence, it's important to establish what your evidence is. This may seem silly, but it helps everybody understand what is being discussed. Make sure your questions for each witness are exhaustive, as you will only get 1 opportunity to question each witness.
Your Honor, I would like to enter Exhibit A into evidence.
Once you've presented your physical evidence, ask that it be marked as an exhibit, for instance, Defendant's Exhibit A, B, C, etc. Then request that it be added into the record.
Can you identify this document?
Yeah. So this is a copy of all the emails I sent the manager over the past couple of months. So the first page, it's the earliest one. I sent it back in August on the 27th. Manager, do you recognize this document?
Yes, I believe I got it when you sent it.
Okay, and why didn't you respond?
I forwarded it to the landlord so that the repairs could be made.
Okay, and the next one, I sent it on September 1st. Did you get that one?
I think so.
Okay, and you didn't respond to that one either.
I forwarded it to the landlord so that repairs could be made.
Okay. Did you forward all the emails I sent you?
I'm sure I did. That's our policy. I'm not in charge of organizing the repairman myself.
After both sides have presented their case, it's time for closing arguments. You can only bring up topics that were already discussed. Make sure to keep your remarks simple, factual, and to the point. In some cases, the judge will rule on the spot. In other others, they will take the case under submission, and you will have to wait for the verdict.
Can you present your final statement?
Yes, Your Honor. Your Honor, my landlord has a long history of refusing to respond to numerous requests that I send her regarding the water, the utilities, just the terrible state of the apartment in general. I believe that because of these things, I should not have to pay the full amount of rent to my landlord, and I ask that you consider the partial payments of rent I gave to her as fulfillment of our rental contract.
Thank you. I am going to take this under submission, which means that I'm going to review the evidence presented today and mail my decision to all parties.
As you saw from the video, it's important to be very prepared when you show up to court and have your copies and perhaps any questions that you have for the landlord written down, or have a chronology that you want to show the pattern of behavior by the landlord or management in not addressing your concerns or requests and failing to comply with their side of the contract. Getting the court's decision. As noted in the example that we just saw, a decision can be taken under submission, which means you'll be mailed the decision by the court. This may mean that the court wants to consider the evidence, and I think it's very common for a judge to take something under submission. A decision can also be issued from the bench. So right after the trial, after everyone presents their arguments, and the judge will announce it, that they're ruling for the defendant or for the plaintiff, and the terms of what that decision means. If you get an order or decision under submission, you'll receive likely a minute order or a summary of what the court found during your trial date. That'll allow you to understand why the court made the decision that it did. After the court decision, what's next? If you win, and for example, it was a non-payment case, the court will order you to pay the back rent that it calculates based on the issues that you raised and the evidence presented. For example, in the scenario we just saw, let's say Tammy tenant had a rent of $1,000, but because she was lacking water and had a roach issue, the court may have reduced the rent to $750 a month, which means she would have a reduction in rent of $250. If she hadn't been paying that amount already, the court will calculate how much of that she has not paid of the months that she still owes and give her about a week to pay the money to the judge or to the court or to the landlord and provide proof to the court that the rent's been paid. And then the tenant would get to stay and pay the rent going forward. The landlord may also be ordered to make the repairs and provide documentation to the court to show that, either the water was restored or termination or extermination services were contracted with to address the roach problem. And that's just one example of how a court may decide a case with the habitability issues demonstrated in the sample case. If you lose your case, the landlord will have to obtain what's called a writ of possession and file with the sheriff's department. A writ of possession is essentially an order of enforcement that allows the sheriffs to come and change the locks. Once the sheriff processes the writ, they will post a notice to vacate on the door of the premises. That notice to vacate will provide 5 days for a tenant to vacate the properties. You will have 5 days to move out before a lockout will occur. And 5 days is the earliest a lockout will occur. And sometimes the sheriff, if they have a backlog, they may not get to it right on the 5th day. In some cases, it may take another week or two. It all depends on the courthouse and the sheriff's department. Once the lockout does happen, the tenant would have 15 days to coordinate a time with their landlord to retrieve any remaining items. We do have a list to help someone prepare for a lockout that identifies important things. You may want to gather important documents, medications, have a bag packed so you're ready. There are times when a lockout can happen when no one's home, and then you lose access to those things. You may have to coordinate with your landlord to get back in the apartment, but you only usually have a few minutes to get necessary items before you're told that you can't remain at the premises any longer. So these are all things that you should consider, and why it's so important to engage in the legal process and to not just let an eviction case go by. You can't ignore something like this, given all of the potential outcomes and impacts that it may have on you. Thank you for joining our presentation. If you have any follow-up questions or have specific advice that you'd like about your case or the potential for an eviction case, you can call our hotline, which is listed below at 1-800-433-6251. And please look out for any live presentations where we may be able to answer questions and answers after or as part of our presentation. Thank you again for joining us, and we hope this was helpful to you in preparation for your eviction court date.